Hello, everyone, and welcome to McGuire Woods' kickoff seminar on generative AI and the law. And I'd like to thank everyone for attending here today. I know AI is kind of a hot topic, and we have a lot of great attorneys who've been thinking about and working on that issue for a number of months, if not years. So we've been planning out a series of webinars to cover the issues related to AI in the legal space. We initially were trying to shove everything into one webinar, but quickly realized either it would be 5 hours long or we would not nearly cover enough material. So we're kicking off today with kind of an introduction on the technology, talking about what AI is and what it isn't, and in particular what generative AI is and how it has been built. And then we'll be diving into intellectual property. We thought that would be a good starting point because, as you'll see, a lot of the fundamental legal issues here go to intellectual property, who owns what, or what can you actually own out of one of these AI models. So we're excited to be talking through some of those issues here today. To introduce myself, I'm Justin Lowry. I'm a partner in the IP litigation and transactions group here at McGuire Woods. A lot of my practice centers around IP litigation, but patent, copyright, trade secret, typically focused on high-tech issues. I also do a bit of IP counseling and working on IP agreements, and lately have been counseling a number of clients on AI-related issues, either AI governance or AI integration. So excited to be talking here today. And Amanda?
Good morning or good afternoon, depending on where you are. My name is Amanda DeFord, and I am also a partner in the McGuire Woods IP litigation department. I specialize in trademark and copyright litigation specifically, but also have a lot of experience in trade secrets, false advertising, patents, and other areas that touch upon intellectual property.
And I'm Lucy Jewett-Wheatley. I'm also a partner at McGuire Woods in the IP litigation and transactions group. I focus largely on trademark and brand litigation, but I do some copyright and other flavors of IP work as well, notably false advertising. And I would say I also do a significant amount of someone said bad things about me on the internet law, which I expect AI will start to figure heavily in.
So as I said, we're going to be starting off with kind of the technology, but the first thing I wanted to put up here is a quote from one of the recent hearings that's been happening on Capitol Hill from Chairman Chris Coons, who leads the intellectual property subcommittee in the Senate. He started off the hearing with this blanket statement: "Make no mistake, AI presents novel questions across a wide range of areas of IP policy." And I think you'll see that throughout this presentation. There are a lot of novel issues being dealt with here and a lot of uncertainty as to the intellectual property landscape with respect to AI. And I imagine case law and regulatory developments and potentially even new law from Congress will be coming out with respect to AI and IP to keep an eye on. But starting out with a technical background, some basic definitions of terms you'll hear here today and over the course of our various webinars. First is artificial intelligence, and this is a very broad term. Artificial intelligence is simply a machine that mimics the problem-solving and decision-making capabilities of the human mind, which is, again, very broad. So any system that's taking in data and trying to do things that humans ordinarily would be doing. If you have something within a power company that's analyzing power consumption and then making decisions on how to adjust throughput throughout the network or how to be running the particular power plants, if you have something that's analyzing demand and then trying to make decisions on what products to produce, anything that you would typically have a human doing from a decision-making or problem-solving perspective. And importantly, AI is not what it's commonly thought of in popular media. If you've seen AI anytime before the last few years, you probably thought of HAL in 2001: A Space Odyssey or the droids from Star Wars or something like that. But that's not how the industry or what the common usage of AI is here today. That's something that's more a general artificial intelligence, which most researchers would say is many, many years off, if almost impossible. So what we're talking about here today are more design models that are still controlled by humans, but are attempting to do human-like things. Associated with that is the concept of machine learning. That's the ability of these computer systems to learn and adapt without explicit instructions. So if I'm thinking back to when I learned to code 20 or 30 years ago, you tell a computer, in these sorts of situations, we want you to do this. Machine learning allows you to create these learning algorithms that you will take in data and then be able to do things without explicit instructions. So, for example, ChatGPT, which everybody probably knows about, is not told explicitly how to respond to certain scenarios. Instead, it's set up with a set of learning algorithms that will learn from huge data sets that will then allow it to respond on its own without being explicitly told how to respond. More specific concept is one of large language models. These are a type of artificial intelligences that are trained on enormous amounts of text to understand existing text and generate original text. So it's essentially something that's taking in tons of data to understand how people communicate and how language works, and then be able to both understand and replicate that language. And then generative AI, which is what we'll be talking about primarily over the course of today and these seminars. Generative AI is a specific type of model that is trained on large data sets to identify patterns and structures within the data and use that to generate new content. And that's the key word there, and that's where generative comes from in the name. The idea is that you're taking in a bunch of data and then using it to generate whole new categories of content or new responses that did not exist before. And usually they're successful at that. Sometimes they often generate things that are a little maybe close to what they were trained on, as we'll see in some of the cases. But the idea is that you're generating new content from this existing data. And generative AIs can work in a number of different spaces. You can have them in pretty much any medium. You have the text-based ones, which I think are what most people know about. ChatGPT, Google's Bard, Microsoft's Copilot are kind of the major examples that are out there, but there are a number of other ones focused on copywriting, editing of text, all sorts of different applications. You have image generators such as DALL-E, which is also produced by the same company that makes ChatGPT, Bing's image generator, Adobe Firefly, which is attempting to build itself into Photoshop and be an image generator tool there. You have audio generation tools, either music generation or voice generation based on a voice print, or just generate computer voice to voice over something. You have video tools such as video editing, creating digital avatars, or potentially taking a script and taking it to video. Pretty much anything that any medium could work with a generative AI or any type of application. And with all of these, the important concept to understand with respect to generative AI is training data. Training data is kind of the lifeblood of what makes up a generative AI. It's an extremely large data set which is used to teach the AI model to be able to understand and then respond to prompts. So, for example, in the case of ChatGPT, we don't know fully what it's trained on, because for now, at least, they're trying to keep that somewhat secret. But from the outside, we know it's trained on articles, books, public conversations, forum posts, public websites, pretty much anything out there on the public internet, as well as a number of private sources, in order to train it to learn everything about language, what words mean and how words interact with one another, how words are the same or different from one another, how sentences are formed, how paragraphs are formed, pretty much everything about human communication it learns through analyzing and looking through tons of data, millions, if not billions, of pieces of text to gather that sort of understanding. And once you've pulled training data in to create a model, you then will provide an input or a prompt, and then generate some sort of output or response from the model. So in the case of ChatGPT, you can ask it something like, write an essay on the causes of the American Civil War. It, through everything it's looked at, will understand what an essay is, what it means when I'm asking it to write something, what the causes of something are, and then what the American Civil War is, and then generate a full essay in response. And importantly, these models are iterative in that if you continue to speak with ChatGPT or one of these other models, it will continue to update and respond. So I could ask it to punch up this essay or to edit this essay in a certain way, or I could send in my own text and ask it to modify it. And image generators work the same way. You can provide a prompt, such as an impressionist painting of a lawyer giving a CLE presentation. And here I have several lawyerly looking individuals wearing suits, sitting at a podium and giving some sort of presentation. I don't know if it understands what a CLE is, but at the very least, a lawyer's presentation is presented there. And similarly, I could even ask it lawyers in the style of an Andy Warhol painting. And now I've got a set of lawyers, which I imagine it thinks is anyone in a suit, that are laid out in the style of Andy Warhol paintings. Now, the big caveat and the big thing to be careful of with all of these models is what's called the black box problem. And essentially, it's that no one really understands fully what's going on inside a generative AI model or any complex AI for that matter, because there's simply too much going on in there. If you have something like ChatGPT, which has analyzed billions of pieces of information and has innumerable connections between words and does dozens of layers of analysis on any particular prompt to understand what it is and how it should be responding, it's impossible to dig down into the system and know exactly, well, what was the source of this particular response? Or how did it decide to generate this response versus respond differently to another thing? There's simply too much there to do that. And that's true for both users, us ordinary users of the system, as well as the designers of the system. They will tell you it could take months to analyze any particular prompt and response to be able to try to understand it. And even then, they probably wouldn't fully get to the bottom of it. So there's this big problem that's sitting on top of the whole thing that you have to think about both from IP and liability and other perspectives. We can certainly look from the outside and try to validate or understand if this is working properly, but if we want to understand why or where the result came from, we won't be able to.
And just to give a sort of illustrative example about that black box problem, for instance, something as simple as asking an AI chatbot to fill in the blank in a sentence, like, we walked to the blank and, ran around the track. Determining the steps the AI took to fill in that blank would take very smart people, a 25-page paper to try and start to describe what happened there. And even then, there would still be aspects of the process that they are not sure what the AI did. So that just gives you an idea of how complex it is, and frankly, for IP generation and litigation purposes, how very difficult it would be to ever trace AI back through.
Yes, yeah, that's completely right. And it has important implications, as we'll see, for example, in the copyright scenario. If you're looking at a particular output, how can you trace back why the AI generated or where the AI generated this particular output from? And if we can't determine that, that has implications then, as we'll see in the copyright space. Now, some just basic example uses of generative AI. You can have automation of clerical or routine tasks, summarization of data, generation of drafts or forms. I can ask it to generate a form letter or marketing copy or anything else that I might ordinarily ask an associate or a partner or an assistant to do. I can have it generate a first draft for me. Advanced data manipulation, handling of complex data sets or handling of large text to edit it or to translate it. And the potential for creative development. The idea is you're generating new content, so you could try to create new media content or edit or revise existing content. And the potential benefits, speed and efficiency. You can generate drafts very quickly, as opposed to me having to dig up a draft of something and try to generate an entirely new piece of work product. I can ask an AI to do it very quickly. Similarly, you have flexibility. You can ask it pretty much anything, and it will be able to respond to your problems. There will, I'm sure, be generative AIs in every economic space that are developed, or for every business type that are developed that are specific for those businesses. But for something like ChatGPT, it's a general model, and you can ask it pretty much anything. And importantly, it interacts in a natural language form, which for all of us that have taken innumerable hours of training on Word or PowerPoint or Excel and learning the specifics of how to interact with a program, if you can interact with something the same way you would be interacting, again, with somebody in your office, it is a much lower barrier to entry. And then, as I said, creativity, the ability to generate new ideas or designs and hopefully generate unexpected responses that you can then iterate on or work from. Now, we'll be covering a lot of the big categories of legal disputes, but I think it's important to understand everything I talked about has major legal considerations going on in it, from the training data that these models were trained on, to the input that you're providing to the model, to the output that you're getting from it. And we'll, as I said, we'll talk about all of those from the IP perspective, but there's a lot of uncertainty around all of those, as you'll see. And with that, I'll turn things over to Amanda, who will be talking about some of the major cases that are going on right now around generative AI.
Sure. So we're going to start with that first part that Justin was talking about, which is the input into the generative AI, the data set that the generative AI is going to use to learn and form its own reservoir of intelligence that will eventually be used from your input to produce the output that is coming out of the model itself. Some of these issues that we're going to talk about in the cases that we're going to focus on here touch upon the output issues as well. So we'll address it all at the same time. But as you might expect, as we start to get into and to start to see litigation erupt over the use of AI and generative AI, the initial sort of trailblazing cases are all going after the models themselves and have a significant focus on whether or not that initial input, the use of copyrighted information, or related issues that come from the use of copyrighted information is actionable under the law. So to start really quickly, just with a high-level overview before we launch into some of the more significant and high-profile cases surrounding this issue, what they are largely going to come down to in the grand scheme of things is a lot of things, but primarily the concept of fair use. And if you're not familiar with copyright law, fair use is one of the sort of get out of copyright jail free cards that a defendant can use to say, yes, even if this was technically an infringement under the law, under the Copyright Act, what I am doing is lawful, and so I can't be held responsible for that infringement. And fair use has 4 different factors. They're up on the screen for you on this slide. You've got the purpose and character of the use, which is basically, is it being used for a same or substantially similar purpose? Is it commercial? Is it nonprofit, educational? The nature of the copyrighted work, the amount or substantiality of the portion used from the copyrighted work, and then the effect that the use has on the potential market or value for the copyrighted work. And so far, most of the attention around the copyright cases is really focusing on the first prong of the fair use factor, and that's because the second, third, and fourth are more implicated when you're dealing with the actual output, not necessarily the input. And so since the cases are primarily at this point focusing on input with a counterpoint of the output, a lot of what we're probably going to see in these early cases is focusing on that initial prong of fair use.
And Amanda, one just comment on how large language models work, which take in copyrighted content that I think is helpful in sort of framing this legal issue and why these cases are going to be very tough, is that how the models work is, for instance, a word that's fed into the AI is given a series of numbers. It's transformed into numbers. The AI does not read it the way a human reads it, or at least not the way we consciously read. And a single word might have 12,000 numbers or vectors. And so, it might have a number that stands for the fact that it is an animal. And so that number will be near other animal numbers. And so the AI starts to create an understanding of all the different dimensions of that word. And that's part of why it's so complex. But what it means is that the materials that the AI is looking at are coming out as a very long series of numbers to which probabilities are then applied to. So right from the beginning, what the AI is seeing is not necessarily what we would view as the copyrighted content, though in some ways it's seeing, sort of every aspect of that copyrighted content because it may be generating far more information about it than we would even normally glean.
So can we go to the next slide? Yep. So the first, and thank you for that, Lucy, I think that's a helpful addition. The first case that has been filed in this space is the Doe v. GitHub Microsoft OpenEye case that was filed in November of 2022 in the Northern District of California. It is a class action lawsuit that was brought by a bunch of source coders who had licensed through an open source license source code that has been used or is alleged to have been used as part of Codex and Copilot, which are coding AI, generative AI that is produced by OpenAI, GitHub, and Microsoft as a kind of joint team. The claims in that case are a little bit different than the ones that we're going to see in the later cases that have been filed. And the reason why is because the open source license for the source code prevents these coders from claiming direct infringement. It's kind of an asterisk as to why you're not seeing a direct infringement issue in this case. but it is a sort of a unique thing that we're not seeing in later cases where there is no license, and so direct infringement or vicarious infringement is also being alleged in the copyright space. So without that claim, what they're basically alleging in the GitHub case, under the Copyright Act, you have the Digital Millennium Copyright Act, which creates additional claims beyond just your traditional copyright infringement claim, claims for alteration or removal of copyright management information. So information that would tell somebody who owns the copyright, who claims ownership of the copyright, is either being altered in the sense that the output that is coming out is indicating that the copyright is owned by somebody else, or it's being removed entirely, both within the data as it exists within the within the AI's training set, and then again in the output stage as well. They have a breach of license agreement claim as well that ties into the fact that the open source license does require attribution when the code is used. They had a privacy claim, they have an unfair competition claim, and some other additional sort of state level claims that relate to the same issues and are quasi-IP or IP adjacent in the case. The big issue that has made this case kind of remain at the forefront is not just the fact that it was actually one of the first ones filed, but the fact that a motion to dismiss has not just been briefed in the case, but has been ruled upon as of May. We're not going to talk about privacy today. The next iteration in this series is going to delve quite deeply into the privacy implications of using generative AI. But I will note that, at least in this case, the court did dismiss the privacy claim that was brought by these coders. It's not because of any indication that privacy claims are not valid in this space. It was just under the context of this specific pleading, the court did not find sufficient facts to allege that either sensitive or personal information was actually being used as part of this process. So that claim was dismissed. For a significant chunk of the remainder of the motion to dismiss, it didn't actually deal with whether these are cognizable claims under the law. It dealt with the issue of Article 3 standing. So standing is obviously a general requirement that everyone has to meet when they're bringing a case, and you might think, rightly or wrongly, that standing would be clear in this case, but the court disagreed and said no. Basically, under the idea of the fact that you have to have, for Article 3 standing, a particularized harm that is directly connected to the issue or the claim that you are bringing, the court actually found that under the current claim, that the output that is coming from this generative AI did not have sufficient proof to show that these specific coders' code was coming out in the output. So focusing on the latter stage, after the generative AI has been trained and taught on the data set, no code owned by these coders is appearing in that output. And so there wasn't sufficient particularized harm for them specifically. And they try to say, well, this is a class action, we should be able to maintain it based on the fact that there are examples of specific code owned by people coming out, and the court said no, and dismissed the damages component. Importantly, the court did not dismiss the claim entirely. And the reason why the claim wasn't dismissed entirely is because under the injunctive relief standard, future harm or risk of future harm can be sufficient as long as it's imminent and substantial. And so the court essentially adopted the plaintiff's arguments to say that just because this platform hasn't yet resulted in an output of their code, which would be a violation of their rights, that is a potentially significant risk that would happen in the future. And so the claim could survive at this point for injunctive relief. Regarding the DMCA alteration and removal claims, the court also denied the motion to dismiss on that claim and found that the plaintiffs have sufficiently pleaded that at the input stage, when their code was taken and put into the draining set, and potentially at the output stage, that the information, the copyright management information, may have been removed or altered. There's a subset of a DMCA claim that the court did dismiss, but gave leave to refile if they could plead sufficient facts that this model was going to distribute the CMI with knowledge that it had been removed or altered. So not a suggestion that claim is not legally cognizable, simply just a fact that at this stage, there weren't sufficient facts to support that type of claim by these plaintiffs, but if they could re-allege facts to support it, it could be a viable claim moving forward. The breach of license claim also survived. That's the claim that I mentioned a minute ago, that the license, the open source license, required attribution and information about the license itself with the code. That survived. And the court dismissed the unfair competition claim, again, not based on the idea that the unfair competition claim isn't cognizable, but that the complaint as pleaded at that point did not allege a sufficient injury. So that one is one that is definitely to kind of keep in mind and watch as it moves forward in the legal sphere. The next case that was filed shortly after the GitHub case is the Anderson versus Stability AI case. This is also a class action that was filed, also in the Northern District of California. But this time it is being filed against Stability AI and specifically with respect to Stability AI's stable diffusion model, which is a text-to-image generative AI model. So essentially, Justin gave some examples at the beginning when he was explaining AI of if I put in, give me a lawyer or give me a painting of a lawyer in the style of Andy Warhol, that would be an example of what stable diffusion does. You give it a text prompt and it produces an image as a result. And so this is one lawsuit that has been filed against Stability AI at this point. And Stability AI is taking a lesson from the rulebook of the GitHub decision and is making a lot of the same arguments against the complaint and a hope to get it dismissed. And that is still pending at this point. The third case that I want to talk about substantively is the Getty Images versus Stability AI case. And I'm going to talk about this one a little bit more in depth. Very similar in some ways to the class action that we just talked about. That class action is being brought on behalf of a number of photographers who have a wide range of claims, not just IP specific claims like your copyright claims, your DMCA claims, but again, there's sort of IP adjacent claims, including right of publicity, California statutory unfair competition claims, and so forth. The Getty Images case is one that I'm going to spend a little more time talking about because in the context of commentary, and commentary by lawyers is commentary by lawyers, so take it for what you will. It's widely kind of been considered so far likely the stronger of the two cases against Stability AI. And the reason why is because with Getty Images, what they're alleging in their case is a combination of copyright claims for copyright infringement, the CMI removal, which I talked about under the DMCA, distribution of or inclusion of false CMI, so the alteration aspect of it as well. But then there are also trademark infringement and dilution claims that are being brought by Getty against Stability AI, which I'll explain in a minute, and how that works and why those are included in this case. So essentially what Getty Images is alleging is that Stability AI's training set and its data that it has been trained upon scraped from the internet without Getty Images permission over 12 million photos. Getty Images includes on its photos on its website watermarks that are there to basically prevent the type of infringement that it's alleging in this case. And one of the big issues that Stability AI is going to have to grapple with and deal with is that, as you can see from the images up on the slides, the output that is coming, not just the input, but the output that is coming out of Stability AI, in some instances, according to Getty, is quite similar to the images that Getty believes are forming the training base for the AI. And so in addition to, again, alleging that the watermark or that CMI is being removed, that there is copyright infringement because you are basically replacing Getty image, an image from Getty Image that you would have to pay for and license to use with a image from Stability AI, thereby taking away revenue from Getty Image. That there's also, as I mentioned a second ago, issues of trademark infringement and dilution. And the trademark infringement comes from, as you can see on the images up there, inclusions of the Getty Image brand on the generative output in some instances, but also the dilution claim comes from the fact that Stability AI, as it's developing and learning, is producing what Getty Images has alleged in some instances are grotesque images, or images that Getty Image thinks is tarnishing its brand. And so the dilution is essentially that there's being damage done to the Getty Images name due to confusion if people think that some of these images that are melding people together or are not, the way that you would want to see these images are in some way connected to Getty Images. Since these 3 complaints were filed, there have been a number of IP challenges to generative AI development that have been filed, a lot of them in California. I suspect we'll see a lot more before this is said and done. And I won't go into the detail of these cases, and there are more being filed regularly. But it seems to be we're going to see a lot of these before we see sort of a stabilization of these lawsuits. And so far they are against the models themselves, or the companies that own the generative AI, not against the end user who is taking the output. And so as you start to think about this, and one of the most lawyerly things that I think any of us can say is we just don't really know how these cases are going to shake out. The law is very early in its development stages. Attorneys on the plaintiff side are testing claims. Defendants on the defense side are testing defenses. But as I mentioned before, a lot of where things are going currently is that a lot of the copyright claims are going to center around whether or not what is being done both at the input stage and at the output stage can be considered fair use. And so as we wait for these issues to be grappled with in sort of this novel new context, one thing that there's been discussion around is whether we can glean any sort of guidance from prior cases in similar contexts to understand how some of these issues might be resolved in the new novel area of generative AI. And so the first one that has come to mind and has been a point of discussion is the Second Circuit's decision in Google Books from 2015. Certainly it's just a circuit decision, but arguably an important circuit decision. And the Google Books case, if you're not familiar with it, involved copyright infringement claims against Google for Google's Google Books function that digitized on the back end, tens of thousands of copyrighted books, created an algorithm that would allow people to search for information. It would generate a small snippet of that book to show you whether the words were within the book. And then Google also, on the side of that, provided digital copies of the books to the libraries that gave Google the copies of the books to digitize in the first place. And importantly, it was one of the more pivotal fair use decisions that we've had in the recent years. And the Second Circuit found that what Google was doing constituted fair use. And the reason that the Second Circuit found that what Google was doing, despite the fact that it had admittedly taken and copied in electronic format and stored entire copies of copyrighted books without permission, and then was allowing and displaying portions of those books to people for free on the internet after if the search terms they ran hit upon those books, was essentially that they found that it was a sufficiently transformative use in terms of the fact that they weren't actually using the book for the book's purpose of providing the copy of the book. It was being used for the public service of allowing people to research in a unique way. Also part and parcel to this decision, important to the decision, was the fact that the display itself was not of the entire book. You couldn't access the entire book through the Google book search. You could only get a small snippet of it. And then if you wanted to continue your research or you wanted to continue to use that information, you'd have to actually go and get a copy of the book. And so in that instance, it is not being used for the same purpose or the Second Circuit found it was not being used as the same purpose as the books themselves or the copyrighted works themselves. It was a limited display of the use of the copyrighted image, and it didn't impact or supplant the use in the marketplace. Importantly, in that case, the circuit also found that the commercial use by Google did not take it out of the fair use context, which if you're familiar with fair use, the commercial aspect of a use is certainly an important factor, but it's not necessarily a dispositive factor about whether or not something is in fact fair use. More recently, as in May of this year, another case that may give some guidance as to how the courts are going to deal with and grapple with generative AI is the decision in the Warhol case by the Supreme Court in May of 2023. A lot of information came out of that case, a lot of analysis, a lot more detail and explanation than I can go into today. But the biggest takeaways from that case that could apply in the context of generative AI, and particularly with respect to images themselves, these text-to-image generators, is that first prong that I mentioned of this fair use, where it's talking about the purpose and the transformative purpose and the nature, the purpose and character of the use is kind of twofold. One, in the Andy Warhol case, if you're not familiar with it, what was at issue was a picture of Prince that, or a painting of Prince that Andy Warhol had put together, and that was being used in a magazine overlay. And the person who owned the copyright of the original image that Andy Warhol used to create this painting was saying that it was infringement and beyond the original license that was provided to Andy Warhol to create not that image or not that painting, but a prior iteration of that painting. And so it was an unauthorized work. And so essentially what the Supreme Court found when it affirmed that the image and the use of the Andy Warhol image in this particular context was not fair use and was in fact infringing, there are kind of two lessons to take away from that. One is that essentially the court said, look, if the image or the work that is being accused as being an infringing work has the same or a highly similar purpose, that's going to be a hard thing to overcome. And in this context, because the Andy Warhol painting was being used as a picture of Prince in connection with an article, the court said that is a highly similar purpose, if not the same purpose as the original image itself, the original copyrighted photograph. They share the same purpose. And then it went on to say basically that if you also have the fact that it's being used in a commercial sense, which there was no argument in this case that it wasn't being used as part of a commercial use, you're basically in trouble in terms of fair use. There's a very low likelihood that you'll be able to prove that the fair use factors come out in your favor and that there's no infringement because of fair use. The second lesson from that, which I think will be very important as we wade through the implications of these claims with generative AI, is the court reminded and reiterated that fair use is a very highly fact-specific investigation, and it's not just a highly fact-specific investigation in the general sense, but also in the specific sense that the specific use to which a work is being put to can govern whether something is fair use or not. So it is not a, end all to be all to say, well, in this context, the use of the Andy Warhol painting wasn't fair use. And so in every case moving forward, we can just say any use of that image is not fair use. Every single use of that image has to be viewed in its own particular context, such that you can have instances where a work may count as fair use and therefore not be infringing if it's used in this specific way. But if it's used in this way, it doesn't constitute fair use and it is infringing. So a lot of things to kind of think about and consider. Practical implications of this, if you are not someone who falls into the category, or you don't work for somebody who falls into the category of actually offering generative AI models, is how does my use, or how does my company's use of AI generative models expose me to liability? And the question is right now that it probably does a lot. Most public terms and conditions for public AI generative models disclaim any sort of responsibility and do not provide any warranty or indemnity to you as part of their service. So it's basically you're using this at your own risk, and if what you get from us ends up to be infringing of somebody else, we're not going to indemnify or warrant or do anything to protect you on the back end. So practically, when you're thinking about setting policies for your companies or talking to your companies and employees about what to do with AI and generative AI, I think we can all agree that the ship is probably already out of the harbor that it's impossible to say that you can stop your employees from doing it. That doesn't mean that it's not, sound policy to try and to say as a matter of policy for the company, we don't endorse this and we don't allow it. But there still needs to be some consideration on the back end about what to do in the event that your instructions aren't followed, if that's the choice you go down, or if you decide to allow it, what can you do to kind of protect yourself? And so I think Justin touched upon this and Lucy touched upon this. That black box issue is one of the biggest issues that companies thinking about using generative AI have to grapple with. You will not know whether or not the output you're receiving is being generated through use or access to someone's copyrighted information. And we do not know at this point sort of the scope of liability that could attach to the use of an output that is generated that is technically infringing on someone's copyright. And so a big thing to kind of keep in mind is as you go through this, if you are going to enter into agreements directly with AI vendors or do something other than just use the public models, which we know don't provide any reps or warranties and don't provide indemnification. Can you negotiate and should you negotiate? The answer is likely yes, you should negotiate some sort of protection from you, some sort of rep and warranty that there's proper licenses in place. There are companies out there that offer generative AI that do claim to have licenses to the copyrighted information that forms the data set that trains the AI. And so getting reps and warranties and agreements and having specific agreements that those exist can help you on the back end should that not be the case and you end up finding yourselves on the end of an infringement suit. Another thing to keep in mind is that you want to be aware and consider not just whether you yourself and your employees or your company are using generative AI, but whether your vendors are. As this area of technology continues to grow, more and more people are likely going to turn to it especially as we start to see more and more of these cases start to shake out and people feel more comfortable with sort of the risk of liability. And so you should really consider and think about asking questions of vendors that you're relying upon to provide you content or provide you with things that could be generated by AI, whether or not they are in fact using generative AI. And if they are using it, what are they using? What indemnities do they have? What reps and warranties do they have? And what reps and warranties or indemnities can they provide to you? So with that, I'm going to go ahead and turn it over to Lucy.
All right. So I'm going to talk a bit about the issues with providing input to a generative AI. And so this is referring to when you put in your data to a generative AI. This can be through a paid service where you've used an API and you've linked in with, for instance, ChatGPT, and you have a limited data set and you're trying to do a specific task. This could also be when your employees are simply going to ChatGPT and using it to accomplish work tasks, and you may or may not know about it. So up here on this screen, we've got the terms, some of the terms of use for OpenAI, which does ChatGPT and DALL-E. Now, on its face, they make it clear as between the parties and to the extent permitted by applicable law, you own all input. So you don't automatically give up your rights to copyrighted content or other content by feeding it into an AI. But unfortunately, it's not quite that simple, because even if you do not give up ownership by providing input to a generative AI, you may be losing the ability to exclude others from your input, your content. And, the AI certainly has the ability to perhaps glean more from your content than you intended. The AI can break content down to many different dimensions. If you feed it a picture, it could possibly tell you, how many brushstrokes are used, all sorts of information you may not be intending to provide, that the AI, because it is a highly sophisticated set of algorithms, can see that you maybe cannot. So even though you maintain ownership of the input according to the OpenAI terms of service, they also note that input is part of what they call content, and they can use content to provide and maintain the services, comply with applicable law, and enforce our policies. Well, what does provide and maintain the services mean? It could mean generate content generally. So, even though you maintain ownership of your input, under their own terms of service, they may still be able to use it. And again, because of this black box problem, you may not really know how they are using it. Also in the services relating to input, if you're using the free version of, for instance, ChatGPT, if you see in section C here, it says, we may use content from services other than our API, non-API content, and that would be include input you're feeding in just on the main website for ChatGPT to help develop and improve our services. So presumably they could use it in training data sets. It's not entirely clear, but the key here is if you are providing input into a generative AI, or your employees are, you may not lose ownership of it, but you at the minimum have lost some degree of control of it. And it may be difficult to impossible to get that control back. So sort of practically, you have to think, what rights am I giving up when I am feeding it an input? If this is important proprietary data to you, you probably want to make sure, A, that your employees are not just using free services with that data. And to the extent you use paid applications, you need to determine if your inputs are being segregated from sort of the general inputs the AI is using. As to what you need to kind of determine, how is the AI using the data you feed it? Again, you have more control if you're doing this through a specified contractual relationship where your data and use case can be somehow segregated off. But that is generally not going to be through free services online. And I think it's important for employees to understand that. Finally, you don't want to provide confidential information. The general AI use policies say, don't provide us any data that will violate someone's rights. So for instance, you certainly wouldn't want to provide patient data, for instance, that's protected under HIPAA. Providing data to an API could definitely potentially violate existing contracts. And it's going to be, again, very difficult to tell if the AI continues to make use of confidential data because you're not quite sure what it is doing. And there's certainly the potential that if you use inputs that are related to confidential patented inventions or trade secrets, that disclosure alone could cause you to lose your rights. Then there's the input question. Can you sort of lose existing rights that you have? But then there's also the output question. What IP can you get in the output of something from generative AI? So going back to the policies for OpenAI, they say, we assign to you all right, title, and interest to output that you have, created through your input. You can use the content for any purpose, including commercial purposes, such as sale or publication, if you comply with these terms. Now, an important caveat to that is compliance with the terms includes a pretty long list of things that you are not supposed to be doing with at least OpenAI's products. You can't use it for multi-level marketing. You can't use it for gambling. You can't use it for political lobbying. You're not supposed to use it for various types of adult content. And they even have broad categories. You're not supposed to use it for activities that could cause economic harm. If you're going to use particularly free versions of, AI products, I would encourage you to look at their restrictions because they can be pretty broad. I mean, these companies are reacting to some policy concerns. So you may be, using it in a way that is outside the terms of use. And so then any promises they make to you may be effectively nullified. Another use case you're not supposed to use it for is in making hiring decisions. So if you're using it to sort through resumes, you may be violating their terms of use, and that may risk certainly your ownership of any output, but it also sort of may subject you to liability. The other big problem with owning output for AI is that you may be able to own it, but so can anyone else who receives similar output. So if your goal is to get something unique that you can use, free versions of AI are probably not the way to go because it can give the exact same content to someone else, and potentially it can give that content having indirectly made use of your input. Another consideration if you are using output from AI is that generally AI requires you to, or terms of use require you to disclose when content was generated using the assistance of AI. So you're supposed to put that on the content. So you need to think about that requirement. And certainly if you are using AI to generate any sort of advertising or you're creating your own influencer, traditional, disclosure requirements from the FTC and under the Lanham Act still apply. So you may need to say this was created by AI when you are putting that content out there to the public. Another big issue with using output generated by AI is that it in no way insulates you from claims that you are violating someone's right of publicity. And, again, the terms of use you will have agreed to by using the AI will say that you can't use it in a way that it infringes, misappropriates, or violates any person's rights. So if your AI generates you a video or a person that happens to be based on a real person, even if you don't know it, using that content may subject you to right of publicity claims. Right of publicity is a state law thing at the moment, and so it varies a lot from state to state. And certainly in some states, the law around right of publicity does not seem to require that you intentionally violated someone's right of publicity. So if the AI spits out, an image of a person that is very similar to a real person, you may not have much of defense, and your sort of ownership may be meaningless because it is violating someone else's rights. And that is particularly true if you obviously are putting in inputs that, give me something in the style of, Tom Waits singing that seem likely to generate content that's going to violate someone's rights. Finally, trademarks, and I'll try and get through this pretty quickly because I know we've got a good bit more to go through. If you're using AI to generate brands, in some ways that is probably the safest IP use case for AI, because if you use AI to come up with a new brand for your company, there's nothing that precludes you from owning that brand. As long as you start using it, you can own it. Now, using the AI will not be a defense from you infringing someone else's brand, so you still need to clear the brand. But AI may be very useful in the sort of idea generation phase, and there aren't the same issues as with copyrights and patents to ownership of the brand. AIs may be useful for gathering evidence of either your priority. I think they can probably scrape the internet pretty well, or you can use them as research tools to determine how long someone else has been using a brand. But again, you do have to still do clearance if you're using AI to generate a brand, because it may make it more likely that it is drawing from third-party inspirations.
All right, recognizing that we are quite short on time, I will say, so we've already talked a little bit, or a lot of it, about the potential copyright exposure to liability on the generative AI output. So if you're using something that is generated by AI and it infringes on somebody else's copyrighted work, we've talked a lot about that and the issues that are there. What I want to talk about here is the guidance from the Copyright Office to date has basically suggested that whether or not you can copyright material that comes from generative AI is questionable. The Copyright Office has taken a hard stance that works that are AI generated only, where the original authorship is coming entirely from an AI model, are not copyrightable. That falls in line with the requirement that there be human involvement in the creation for copyrightability. The question mark where we will have to see how the Copyright Office starts to handle this and grapple with it is, what do we do when a human being, after receiving the AI generated material, then adds additional work or additional original elements to it, whether it's moving things around in terms of creating an original compilation or some other type of original copyrightable addition. The big question there is what the Copyright Office and eventually courts that have to hash out challenges to dual created copyrights are going to consider to be sufficient human involvement for copyrightability. But the overall long-lasting message is still, as typical with all copyrights and registering and ownership of copyrights, that even in instances where you have a dual human AI created copyrighted work, only the portions that are a result of the human authorship are themselves copyrightable. You will not have ownership in the AI generated content, even if a human being takes that and adds original elements to it.
Yeah, and you'll find similar guidance in the patent space. There's currently no ability to patent anything that is quote unquote invented by AI. There was a test case that was filed by an AI inventor known as Dabas that was taken up to the Federal Circuit after being rejected by the Patent Office for having no human attached to it. And the Federal Circuit found that inventors must be human beings under the Patent Act. Now, so far, how that has worked out is that tech companies, the USPTO, pharmaceutical companies, others that are using AI as part of the invention process are attaching human inventors to it. And essentially, there's been an agreement that what the AIs are doing is not invention. It is something else. And the humans that are involved in this process are the ones that are actually inventing things. So if you put a human inventor on your patent application, you're still going to get it through the Patent Office and be able to get an allowed patent, assuming it meets the other requirements of patentability. That somewhat dodges the issue, though, because years down the line, if you're now litigating on that patent and you have an actual opponent who's digging into the invention process, they're going to be looking much more carefully at, well, what did the humans do in this process? What did the AI do? And is there a real human inventor here? And so questions such as, if you have AI conception with human reduction to practice, AI assisted invention with some substantial human involvement, what is actually going to be the line there is very unclear. And I think there's going to be lots of risks years down the line in litigation with AI related or AI generated inventions those being challenged in court as being unpatentable. So it's something you need to be thinking about now. In terms of kind of the overall guidance with respect to use in AI in the IP generation process, you just need to be aware that as soon as you put AI into that process, it could infect your development of that IP in ways that you're not expecting. Similar to you bring in open source software, it expands out throughout your software platform and clouds your ownership. So you have to be careful about using it for anything mission critical. You should document or keep track of what the human involvement is in AI-related discoveries or AI-related creations, and make sure that you're keeping track of that and emphasizing the human element. You don't want your inventors or your creators sending out emails that say, hey, the AI spit this thing out and it's amazing, and I never would have thought of that. Because that's going to be an amazing thing for me as a defense litigator going against your invention or your creation. So be considering those things and messaging that to your creatives right now. And again, as always, consider your reps and warranties with contracts that you may have around IP that you're acquiring from others that may have an AI component. And I don't think we have much time to get into it. The last thing we will cover real quickly is kind of the future of IP litigation. Be thinking about discovery and document retention, which get very complicated around generative AI models and how you're going to be tracking how the models are working or how they've been trained. Start thinking about those things now, knowing that those models could be in litigation later. Consider those proof of ownership and proof of development fights for AI-related IP, and be, again, thinking about that now, documenting human activity, making sure that you can tell the stories you need to tell around your IP later if you end up in litigation. You don't want to be in front of a jury where an AI is the one that really did everything, because you still need a human to tell your stories in front of a jury. And then I think, Lucy, the last thing, I don't know if you want to get very quickly.
Yeah, very quickly. If you own a brand, you should consider how AI could speed up the process of genericide, or turning your brand from a brand to a sort of generic term for a particular class of technology. It's unclear how well AIs will understand brands. And again, with all new technologies, and AI is no exception, it's going to increase the speed of everything, and it's going to increase the volume. It just can generate a tremendous amount of content. So to the extent it is misusing your IP or some way and weakening it, it is likely to just move a lot faster and require attention sooner.
And one thing, because I know we're out of time, that I'll just add on to the future of disputes and what to think about. Justin mentioned very quickly keeping good records. Good records is going to be useful to you both in terms of fighting challenges to IP ownership that you have, whether it be copyright or patentability, to be able to show, for example, in the copyright space, the human edition that's not just from an AI model. But also in terms of infringement, all IP infringement comes with the risk of enhanced damages for willfulness. Keeping records, if you're using generative AI, of what your input is, can be helpful evidence that even if what was given to you was eventually technically infringing and subjects you to liability for that, it wasn't done so intentionally, because you didn't say specifically, give me a painting in the style of Andy Warhol. You said, give me, some sort of, painting that has a lot of colors, or whatever you want to say, and somehow it came out looking like Andy Warhol's paintings. So keeping those records are important. They seem mundane, they seem unimportant at the time, but you never know when something is going to necessarily result in infringement, and so, or a challenge of infringement, or if you're going to need to bring a claim. So having those records when you need them to show why whatever you're saying is correct is useful to think about.
And with that, I know we're over time, so we very much appreciate everyone attending today. If you have any follow-up questions, feel free to reach out to any of us on any of these subjects or anything related to AI or IP. We love talking about this because it just gets very philosophical and very strange very quickly, so it's just fun to talk about. But if you have any specific questions, as I said, reach out to us. And otherwise, I hope everyone has a great afternoon, and look out for further invites to AI-related seminars from McGuire Woods.